Us today for our Art and Law Trinidad and Beyond workshop. I know there are some folks still trickling in. We have a really great turnout signed up for today. And we're excited about this workshop this morning, which is being presented by the organization I work for. I'm Meredith Badler. I'm the Deputy Director at the Colorado Business Committee for the Arts, the CBCA, in conjunction with one of our programs, Colorado Attorneys for the Arts. And today's workshop is in partnership with the Corazon de Trinidad Creative District and sponsored by Colorado Creative Industries, our state arts agency. We have a very full and exciting program today, so I'm going to zip through a few housekeeping slides before turning it over to some of our presenters. Just some Zoom tips. You've all managed to log in, so well done there. We ask that you stay muted. You were muted upon entry. That just helps avoid background noise, dogs barking, people delivering packages. So we appreciate that. You do have a wonderful chat feature, which I encourage you to find now. Find your little chat feature and introduce yourself. Say hello, give us your name, where you're dialing in from, maybe what kind of art you do. Are you a musician? Are you a painter? Are you a sculptor? Are you a writer? Introduce yourself in the chat. That's also how you'll be asking questions to our speaker today. We want this to be very interactive. We are here for you and your education. So please find that feature and use it throughout. When we get to the main presentation, we invite you to either turn your camera off or go into speaker view. It's nice to sort of see everyone in that Brady Bunch gallery view, but especially when we turn it over to our printmaker, Amanda, and Dave, our speaker, going into speaker view will just allow them to sort of take center stage. There's a nifty video setting called hide non-video participants. So anyone who has their camera off will kind of blink away. We encourage you to do that. We also have closed captioning available. You can find that at the bottom of your screen. And then we'll be recording today's presentation so we can share it later. A little bit more about CBCA. We are a nonprofit 501c3 based in Denver, but we work all over the state, and we're so delighted to have people from all over Colorado joining us this morning. And our mission is all about that connection between arts and business and the arts. We do advocacy, research, leadership development, trainings and education, volunteerism, and all sorts of arts and business engagement programming to really leverage that mutual benefit when arts and business come together to support our communities and our economy here in Colorado. And we know right now, in particular, here in 2020, that intersection has really never been more important. And I mentioned that this program today, or this workshop today, is in conjunction with one of our programs, Colorado Attorneys for the Arts. This is a statewide referral service that connects artists and performers and creative entities with pro bono legal help. So we have over about 120 attorneys in our database, including some that you'll hear from today, that offer their legal assistance either through education or through actually representing artists to fulfill their legal needs. So there's our website, some of the information you can find on our website, such as how to apply for one of those referrals. We have a great resource list, and then our email address and Facebook is there as well. So for this morning, we have a workshop this morning, and for those of you that had signed up in advance, we are offering some one-on-one consultations with our attorneys, different attorneys that are part of this program as well. So I'm going to turn it over to Marilyn Lusler with the Trinidad Creative District to talk a little bit about what they're doing. They really have been our partner in crime putting this event together. We are so grateful to the Trinidad Creative District. So take it away.
Hello, everyone, and thank you so much for joining us. We really appreciate your taking the time to uh, participate in this wonderful opportunity. And thank you to Meredith for all of her hard work and in putting this together for us during this time when it's not in person, but rather virtual. So we greatly appreciate all the time spent. I'd love to tell you a little bit about our creative district. We were certified in 2013. And then in 2015, we were designated as the demonstration project for Space to Create Colorado. So that has taken a great deal of our time and energy and effort over the last 5 years. And we do have artists and others in residence now in our affordable live work portion of Space to Create. And in the next year, we'll be opening 20,000 square feet of multi-use community space in the commons at that location on Main Street. So that's been very exciting and helped to make a lot of the change that's taken place over the last 5 years in Trinidad. It's my great pleasure this morning to introduce Amanda Palmer, who is an artist, one of those who first came to the Trinidad History Museum's Residence in Artist program and kind of fell for Trinidad. So she now is a permanent resident and has purchased a home and opened a studio and business here in town. So we're thrilled to have her with us this morning to demonstrate her printmaking. So Amanda, I'll turn it over to you and you can tell us a little bit more.
Excellent. Well, as you know, I'm Amanda Palmer. I've been an artist all my life. I want to emphasize that I loved art, all forms, including drawing as a kid, and was always encouraged by my family, which is really wonderful. I just want to start a little video here to run in the background without sound. This is a part of a presentation I used to do for artist residencies. So I'll give you some visual sideline while I chat. On a personal note, my twin brother moved to town recently and got a space at Art Space Loft. So he's living there and really excited about that space and the future of our little town. As Marilyn said, I had an artist residency at the History Museum here in town. But I'll go a little ways back. I have a BA from San Francisco State University with an emphasis in printmaking. I've been doing printmaking for over 30 years. That includes art education for children and adults in just sharing my love of relief printmaking, but also drawing instruction, Photoshop instruction, anything you can think of that I even waited tables to try to make a living. So here I am. But I owned a gallery in my 20s in Northern New York with my husband, who was a photographer. We had a wonderful space there. He did his matting and framing, and he had a dark room, and I did art instruction. And basically my job was to show up, sell our note cards, sell artwork, and draw all day. So it was wonderful. In 2014, we started traveling every winter. And during that time, I realized there were these artist residencies available all over the country, all over the world. So I started applying to those. I've been awarded 12 residencies, 9 of them in national parks, and 1 still upcoming at Mojave Desert. I received the History Museum residency. I was the 3rd to be awarded. And then my husband died suddenly in 2018. So I was scheduled to come here that fall. And I decided to just come out here by myself. And as Marilyn said, I completely fell in love with town. I made wonderful friends, especially the Art Car Museum friends, Rodney Wood and Susan Palmer. A lot of people really took me in, and I fell in love with the Southwest terrain and the wonderful environment, and the winters are so mellow here. I'm still wearing a t-shirt. The thing I loved about artist residencies was more than anything, it forced me to be in the moment, in a space, in a park that I probably never would have visited. And so I had to learn the history of the area, learn the significant parts of that park or the town here in Trinidad, and then interpret it for others. So I don't know how well you can see it because of glare, but one of my Trinidad images is in the background. But today I'm going to demonstrate the printing on my 1937 Vandercook proof printing press of my current image, which is Divine Equus. So this was inspired by a logo I did for Happy Rascal Ranch in Flecitas, New Mexico. It's not anything like their logo. It's just that I got so into the horse imagery over the years, over history, that I had to reinterpret it myself. So you won't be able to see everything. I don't know if you can see, I have a palette of ink laid out behind me. I'm going to roll ink onto this relief. This has been carved. Sometimes, well, I often am asked how long does it take to carve an image, and I usually just say 30 years because that's how long I've been doing this. So without further ado, I'll print for you. Candy roller, black ink. I use oil-based ink. I am begin to move into Japanese style of printmaking, which is called mokuhanga and is generally water-based inks, just because it pushes me to do color. I just love the graphic quality of black and white. However, I think some things require color. So at this point, I'm just trying to roll evenly throughout the image, all of the edges. I normally wouldn't be rolling this right on my printer because I try to keep that clean, but I have paper below it, so we'll do a little switcheroo. I do a lot of workshops because I love to do relief printmaking and I love to pass it on to children and adults. National Park residencies especially really love you to do a public program of some kind. So often I would either do a demo like we're doing here, or I'd hopefully do some kind of program with kids or adults. Is the most amazing one that I was awarded. Just such a great town and a really cool space that you get to live in for 3 months. So here we go. I think we got enough ink. I'm going to remove the piece of paper I have under here and then align my block on this press. I just bought this press last year, so I'm still working out the bugs, but you'll get the idea. Then clean the hands. I used to, with all of my residencies, I hand printed the images because obviously you can't bring a 500-pound press with you. So I put the paper down on the inked block and then rub. It took about 10 minutes with my images, which are generally 12 by 18. So I'm really excited to have a press to do the work for me. So this is a proofing press. All it does is add pressure. Here we go. Simple as that. I have another press, which is an etching press, also pressure. And the reveal. Here we go. There you go. The finished print. Let's see how. Hey, okay, we're getting there. So that's it. Now, I don't know if anyone had any questions. I can't see your questions because I'm half blind and the computer's halfway across the room. But Meredith, I pass it over to you.
Thank you. Thank you so much, Amanda. It's such a joy to be able to see artists in their natural element and that creative process. I personally find printmaking fascinating in having to do things in reverse and the equipment. So thank you, Amanda, for sharing that with us today. A little bit before I turn it over to our speaker, just to give a little bit of background on sort of this event today. CBCA, in partnership with Colorado Creative Industries and their Creative District program, has been doing these art and law days all over the state for the last 3 or 4 years now. And we usually do them in person in the Creative District for that local community. We were lucky enough to actually be in person in Grand Junction and Telluride this September, all outdoors, doing these workshops under big tents. And we had this workshop with the Trinidad Creative District has actually been in the works for probably a year and a half. We have been working with the wonderful folks in Trinidad and the great artists and creatives there to bring this programming to you all. And when we realized we had to do it virtually, we still wanted to make sure we were highlighting the local artists and creatives in the area. So that's why if you're joining us from the Southeast Colorado region, this program was available to you for free. And that's why we invited Amanda and later on James Richmond on guitar to actually bring us some music so we really can highlight this local community and make it feel a little homey, which is important to us. But you all, you're here because you want to learn, and we appreciate that. We have invited Dave Ratner with the Creative Law Network to lead today's workshop. Dave, I'll let him give his bio of sort of how he got into this line of work, but he's been involved with CBCA and Colorado Attorneys for the Arts since the beginning. Really helped us conceptualize this program and launch it 5 years ago. And I honestly have lost count of how many of these workshops and presentations he's done for us. So all that to say, he knows what he's talking about. And so please ask him questions. This is best when it's interactive. And the presentation this morning will be covering sort of the basics of copyright. That's really a foundational concept for anyone who's working in the arts. But then we understand in this particular moment right now in 2020, when so much of is being offered virtually or digitally or online, there's some nuances about how to better protect your work and how to make sure if you're using other people's work, you're doing that appropriately. So I'm going to turn it over to Dave. He'll be giving this presentation until about 11:45-ish, and then we'll end with some live music. There you go. Take it away, Dave.
Thank you, Meredith. I appreciate it. I'm looking forward to that live music, but we will talk about copyrights in music for a while before we get there. And as Meredith said, please post questions in the chat as we go. I do plan on covering just about everything I can, but still, really, this presentation is for everyone in the room. so to speak. And so we want to make sure we're answering your questions, providing information that is helpful to you. I did prepare a PowerPoint, which I'll bring up here so you don't just have to look at my talking head the whole time. And see if I can share my screen here. Great. So this is meant to provide us some guidance. It's not the only thing to talk about, but what we're going to do is as it implies, talk about what we can post online, why and why not, and really what underlies the answers to that question is all about copyright. So that is why we're going to spend a good amount of time talking about copyright and the basics of that concept of that area of the law, so that so you can then use it to basically in your work answering these questions. And I know it's a really great group of folks that we have here today from all different areas of the industry, creative industry, that is. And so I know different of you have different perspectives. Certainly, like I said, please speak up and ask questions, because that's what will keep it interesting. Unfortunately, my chat tends to disappear sometimes, so Meredith will be able to pipe in and tell me when there's a question in here. So a little bit about me. I am an attorney, obviously, but I also refer to myself as a recovering band manager. I spent years, actually, before I was a manager, I was a tour manager. Before that, I was just a roadie. I have driven a 43-foot bus full of musicians all over the country, been to all 50 states doing so. But really the thing is when I was managing bands, I was doing the business side of the art. The musicians were making music, I was doing the business, and I realized basically every time we got a contract, I need to find a lawyer to read it. And so realizing that there was not a plethora of music or entertainment attorneys in Colorado, I went to law school and realized, wow, there's a lot more here than just contracts, specifically this intellectual property that underlies everything we do in the creative industries. And so we basically, I basically took that opportunity to apply my legal background to the arts, and started Creative Law Network, which is a law firm focusing on the creative industries. We provide legal services to creative people and businesses. And so this question of, hey, what can I post online, is something we've been getting a lot of. Ever since March, it has been a nonstop issue, which is entirely understandable, right? I mean, this is the way that we have to operate these days. So understanding copyright and how it interacts with, or how those copyrights can be used on the internet, is really important to our daily lives, for better or for worse. So basically, the idea that what we post online is really made up of copyright, at least for everybody who's involved in this conversation today. And even outside of that, I mean, even if I'm an accountant putting together a presentation and I'm using some images in my presentation, there's going to be copyright in those images. Because when we put an online presentation together, we put something on social media, put something on our website, we're basically usually putting copyrighted works on our website. So we take music or some video, some still images. We may put words on a screen. We may have some choreography, some dance, something. All these creative aspects are all protected by copyright. And when we take, and some people say, well, I'm putting this new thing on the internet. I'm posting this new work. So I'm going to take someone else's music and someone else's video and put it together, this new thing. That's still using someone else's work. It's still using copyrighted work. So we really want to understand the background of copyright to figure out the answer to that question, can I post this? So we'll talk about what is protected by copyright, because copyright protects any sort of creative work. So this is the list from the statute, from the copyright law, the federal copyright law, that lists literary works, musical works, dramatic works, choreographed, PGS, pictorial, graphic, and sculptural. So we think about everything in the creative space is generally protected by copyright. And And the exception to that is that what is not protected by copyright is ideas. So the fact that you've thought of a great story doesn't mean it's protected by copyright. It is just an idea. For an idea to be protected by copyright, it must be fixed in some way. And fixed means written down, captured, recorded. When we originally started with copyright, it was only written down because we didn't have computers, we didn't have data the way that we do now. But the law says it has to be fixed in a tangible medium of expression. What that means is captured somehow. So if you take a photo on your iPhone or any phone, any camera, digital, you've captured an image, you've created that photograph, you own the copyright in that photograph, it is fixed even if we can't touch it. You don't have to have a physical photograph, a printed out photo to have the copyright in that photo. It's fixed in ones and zeros. It's fixed in data. Um, and and that is basically the fixed, and having some modicum of originality is it's a very low bar to create a copyright. So that's pretty much all we need to do, is have something creative, original to us, that we fix in some way. Other things not protected by copyright: systems and facts. So people will come to me and say, there's actually a very famous case about copywriting the names in a phone book, right? It's just, well, that's just a list of names. Those are facts. They're not copyrightable. What's copyrightable is the arrangement of them. Someone took the time and created that arrangement. So that is protectable because it's more creative. So copyright, by the way, is intellectual property. Okay, so it is property that you can own, that can be bought and sold, but it's intellectual property, so it isn't tangible. The copyright exists in the creative work, but that if I take a photo and print out the photograph and I give that print to someone else, I'm not transferring the copyright because the intellectual property doesn't exist on that print. It exists because it's intellectual property. Kind of a weird thing to grasp sometimes. But as I go through this today, we'll try and exemplify how that applies. And we'll talk about allowing use of a copyright so that we can figure out why we have the arrangement that we do. And all these things, the notion of it being intellectual property and not tangible fits with the fact that we're all doing this online. We're talking about, can I post this online, which is really goes very well with the idea of, well, copyright is an intellectual property, not tangible. So I'm talking about copyright, but the question is, what does that mean? I have this copyright. What does that do for me? What can I do with that? So the idea of owning a copyright in a creative work means that the owner has a set of exclusive rights. And exclusive rights means the owner is the only person allowed to exercise these rights. So the owner of the copyright is the only person that is allowed to reproduce the copyright, prepare derivatives of it, distribute it, perform it, display it. So if I own the copyright in the photograph I just took, I'm the only one allowed to make copies of it. I'm the only one allowed to distribute it. So to post on the internet, or to sell prints of it, or to put it on social media, which is obviously an important topic for today. Preparing derivative works is a very important and often used exclusive right created by a copyright. A derivative work is a work based on the original. So if I took my photograph and went and made a painting of that photograph, that painting is arguably a derivative of the original. If we take a book and make a movie out of the book, that is a derivative. But also, if we take a song and rearrange that song, or we take a bluegrass song and make a reggae version of it, those are also derivatives. And this is often the question of, can I post this? Can I use this copyright? People will say, well, I changed it. I took this copyright, I took this photograph, but I used some filters and I changed it. So now it's mine, right? Well, it's not. You took a photograph, you created a derivative. You used some filters to change how it looks, but you made a derivative of it. The only person allowed to make that derivative is the owner of the copyright, because the owner of the copyright has this set of exclusive rights. The owner of the copyright is the only one allowed to create a derivative, allowed to reproduce it, allowed to distribute it. So this is really important. We think about, hey, can I use this person's copyright in my whatever? Well, if you're doing any of these things with someone else's copyright, you need their permission. They're the only right ones allowed to use it. There are exceptions to this, and we're going to talk about that today. There are ways to post things online, but I'm going to give you the, hey, here's all the reasons, things to think about before we go post other people's work. And I realize, by the way, that we have a lot of different people in the meeting today, in the Zoom with us today. Some of you, a lot of you I know are creating copyrights. So you're looking at this from the owner's side. Others of you are looking at, can I post other people's copyrights? And I'm sure a bunch of you are on both sides. So I'll try and present it from both perspectives. So I think, after talking about what rights are granted to the owner, the question is, who is the owner? Who owns a copyright? By default, the owner of a copyright is the one who created it. So the creator, we say the author, is the claimant, which is the legal word for the owner. So when I take that picture, I own the copyright in that picture. If I write down a poem, I own the copyright in that poem. And this is, again, this is just by the default. It also is worth saying that if two people contribute to a work together, so let's say, I don't know, someone takes, Amanda makes this beautiful, a beautiful print, and then someone else is coloring in over her print with her permission, of course. The two of them, that colorful print or that colorful work, will be joint owned because the both of them created it together. Two authors of a book jointly own the copyright in that book. The exception to this rule that the owner is the creator is in the scope of employment. There's a term called work for hire, which many of you may be familiar with, but a work for hire is when someone is hired to create a work and then the hirer, the employer, owns the work. So if an employee creates a copyright work within the scope of their employment, then the employer owns it. Example would be maybe a reporter for a newspaper. Okay, a reporter for a newspaper is writing articles. Their job, the scope of their employment, is to write articles. So the copyright in that article is owned by the newspaper. Companies that have an in-house design department that is creating designs, those designs are created by employees within the scope of the employment. So the other way copyright can work, if you're not an employee, but you're a contract worker or you've contracted someone, let's say I hire someone to create my website. Website's a creative work, has artistic merit. And I have a contract with that person. They're not my employee, they work for lots of folks. But if that contract between me and the web designer says, this is a work for hire, I own it because I'm hiring you, then I can own that creative work as well. So there are a number of ways, a few ways that copyright, that work for hire works, but by default, the general assumption would be the creator owns the work. I see you have a question in the chat. Does a statement designating the copyright remains? Thank you, Marilyn. There's a question here about a statement designating the copyright remains with the artist. We don't even need a statement. By default, the artist owns their work. There does not have to be a statement that an agreement of any sort. The law says that when you create something, you own the copyright in it automatically. And we do have a registration process that I can talk about briefly, but we don't need anything written to say the artist owns the work. We do need something written if the artist is hired to create the work and the person hiring the artist is going to own the work, again, as a work for hire. If there's ever any transfer of ownership, it must be in writing. There's some things, and there's a lot of things in the law that we can have an oral contract. We don't, as lawyers, don't encourage oral contracts. As lawyers, we want everything written down. But the law allows for oral agreements in some circumstances. Copyright transfer is not one of them. The law says that to transfer a copyright, it must be in writing. So the handshake deal, so to speak, is not something we can use when someone is being hired to create a copyrighted work unless they're an employee within the scope of their employment. Also, if you say, hey, I really like what you've done, I'd like to buy that, I'd like you to transfer that copyright to me so I can own it, I can buy it from you, that has to be in writing as well. So that is an important thing to keep in mind. Another thing that is worth mentioning briefly is copyright registration. So the artist owns a copyright as soon as they create the work, as soon as we lift our pen from the paper. And that ownership, that copyright is effective. However, we have a copyright registration system with the US Copyright Office that, and we need to have if there ever is an infringement, which I will talk about in a bit, an infringement action, if an artist wants to go prosecute an infringement, needs to pursue someone in court, you need to have a registration in order to pursue an infringement action. So for creatives on the call here who are creating in a commercial setting or are putting their work out on the internet or anything, registration is a really valuable tool, and it's not particularly expensive. The filing fee is $55 to $65. It can be a little complicated. The Copyright Office website is not the easiest to use. It's copyright.gov, by the way. You can go to copyright.gov and read about all this stuff. But a copyright registration is very important to protecting your creative work. The other thing I'll mention is what we call the copyright notice, which is the circle C, the capital C in a circle, which whenever an artist creates a copyright work, you put the circle C with the year of creation and the owner's name, and that is a way of putting the world on notice that you own this copyright. You're saying, I'm claiming this as mine, and that's a valuable tool as well. And I see, Marilyn, you've got questions about other people using copyrights. I will get to that, I promise. And any questions I don't get to in the chat, I'll get to at the end. We'll do some Q&A at the end as well. So another question about copyright is, how long does it last? The copyright term, which is the length of copyright protection, is 70 years after the life of the author. So I take that photograph today, I own the copyright in the photograph. That copyright exists until 70 years after the date of my death. It's a very long time. People say to me, oh, well, you know, this photograph was taken back in the 50s, so it must not be protected by copyright anymore. It very well may be. The copyright term has changed over the years many times. We go back to the Copyright Act of 1909. We had a 14-year term, not a 70-year term. Then it became a 28-year term. Then it became 28 years plus a 28-year extension. So it's not easy to say how long is this copyright going to last without doing some research. Generally, if it's older than 1978, basically. So that's something that we do for our clients sometimes, is to help figure out, when does this copyright end, or is this still protected by copyright? Exception to the 70-year rule is if it's a work for hire, it is which are 95 years after first publication or 120 years after creation, whichever expires first. So most things you're going to find in the digital realm, a lot of them are still going to be protected by copyright. When the copyright expires, it goes into what's called the public domain. And public domain is basically where copyrights go to die, basically. So things that have expired, the works of Shakespeare are in the public domain. A lot of classical music, the Beethoven and Bach compositions, are in the public domain. And when something is in the public domain, it is no longer protected by copyright, which means the owner doesn't have those exclusive rights anymore, which means anyone else can exploit those exclusive rights generally. So when we are looking for works to post, if we're looking for things to use, things that are in the public domain are, for lack of a better term, free to use from a copyright perspective. As I said earlier, it's tough to figure out what is in the public domain. Generally, anything in the US created before 1925 will be in the public domain. There are different copyright rules in different countries. So not that, so if it was a Bach or a Beethoven, a European composer, the copyright term in their composition may be different within the last 100, I mean, not as far back as the 1700s, but more recently. So this does take some investigation. And it does take some time to figure out what is and is not in the public domain. But we want to be sure about what we're using. We don't want to use someone else's copyrighted work without permission because we don't want to commit an act of infringement. Infringement is using someone else's copyright without permission. And it is something that, as artists here on the call, we certainly don't enjoy, don't appreciate, right? That really we own these copyrights. We don't want someone else to use them, and really any use of someone's exclusive copyright without permission is considered an infringement. An infringement is a violation of federal law. It is the copyright law is federal, and prescribes some pretty harsh penalties for infringement. I know no one on this call wants to commit infringement, and I'm just going to help figure out or explain where the lines are, basically. But also, I think that there is, for a lot of folks, maybe folks not necessarily on this call, there are a lot of folks who don't necessarily understand the they understand because they're not artists. There's a lot of folks out there who are not familiar with copyright and don't realize that this is not an okay thing to just grab someone else's photo and throw it on your website. And so part of this is just education. Part of why we're doing this today with CBCA, and also so we can spread the word about this, because no one, I don't think anyone out there goes out says I want to commit infringement today. It's not I think most people generally want to respect the rights of authors, rights of creators, and so we have these penalties for infringement, and they're pretty severe. If someone who is guilty of infringing a copyright may have to give up all the profits they've received, so any money that's come in from the use of someone else's copyright, and damages can be up to $150,000 per infringing act. So it's a pretty steep fine. And a court can issue a restraining order saying restraining someone from using the copyright, requiring them to take it down. It can involve the destruction of items. So if you've made physical items using someone else's copyright, a court can order that destruction. And an infringement action can also award attorney's fees, meaning the loser has to pay the winner's attorney's fees. And that, unfortunately, attorneys can be expensive. So that can be a pretty serious penalty as well. So from the side of, can I post this? And well, no, you can't, that's infringement of copyright. Well, I don't care, I'm just gonna do it anyway. Here's our list of reasons why we don't want to infringe copyright. It is meant to be a good deterrent. And I think for most people who understand, it is a good deterrent. Again, a lot of it is about education. So I'm talking about copyrights and what we can't do, right? So we say, well, someone owns that, you can't use that, or I own this and no one else is allowed to use it. But how do we use other people's copyrights? And that's really a lot about what we want to talk about today. Well, I guess before I get to that, I will say that people say, how do I know if something is protected by copyright? As I said, most recent work, certainly everything since 1978, there is a database on the Copyright Office website. Not great, doesn't show you pictures, doesn't let you play the song that you're looking for. So it's a start. It is a tool that we use, but when someone, it is only one tool in our toolbox to figure out, can I post this? Can I use this copyright? The easiest way is to contact the copyright owner to say, hey, can I use this? Do you mind? Can I get a license? And that's the main way we can post it. This is the main way I can post this. The main way I can use someone else's copyright is by getting a license. A license is, this is actually kind of going back to Marilyn's question about designating in writing that an image can be used for something. That is getting a license. A license is a specific grant of rights from the owner to another party. So if I take that photograph and Marilyn wants to use it for a specific purpose, I can grant her a license, again, in writing, ideally. I can grant her a license that says, yes, Marilyn, you can use my photograph, and here's how, why, and when. And that is, we'll talk about that, the specifics of a license, because the specificity of it is really important. A license can't, it's, people say, oh, well, the owner sent me an email that said, yes, I can use it. Did they say what you can use it for and when you can use it and how you can use it? So these are details we're going to want to talk about. Um, there are two main types of licensing, and I will talk about both, but just to kind of create the concept or start the broad brushes of the painting here. There's a direct license, which is what I was giving an example of, which is me granting Marilyn a license in my photograph. Direct license from one person, from the owner to the user, the licensor to the licensee, saying that you can use it. There's also what we call blanket licenses. Blanket licenses are for a multitude of works that can be granted all under one license. And we see this regularly. There's a lot of what we call stock photography websites like iStock Photo or Getty Images. There's stock photo, there's stock video, there's stock music, and these can be really good resources because they have lots of works to use, and you can get a license from them for all of these works. There's also certain blanket licenses granted through interactions with websites and other things. I'll talk about that a little bit, but there's this other option. For one is going and finding the owner, another is finding a blanket licensor to grant rights. In any situation, and I sound a bit like a broken record, we do want a license to be in writing. It is the only way we can prove that it actually happened, right? And that is really, in my line of work, I mean, I can only speak from my own perspective. And in my line of work, I hear from people when there's a problem. And oftentimes the problem is there wasn't a clear license. There wasn't definitive writing, something definitive in writing that said this is what you can and can't do. So it's just my experience, my perspective is what informs what I get to share with you today, which is when things go wrong, it's really helpful to have something in writing. So what do we put in that writing? A direct license, I always say, has to be detailed, specific, and explicit. So obviously we're going to say, what is being licensed? So again, in the can I post this world, where you want to use someone's photograph on your website, we're going to have a license that says what is being licensed, what use is allowed, in what formats, territories, length, and payment. And so I'll go through these briefly because it seems like, well, this is all kind of obvious. It should be, but it needs to be explicit. So what is being licensed? That should be fairly straightforward. It's a photograph or a song or a video. Are the most common things we're posting online these days. And we want to be specific. Maybe we attach an image, an example of the photograph or a link to the video, something like that. But what use is allowed is really important detail to get into, because we want to say, are we allowed to make, I'll keep using the example of a photograph on a website. Is it only allowed on one page, or is it allowed on multiple pages? Can it be in the header so it's on every page? And am I allowed to alter it in any way? Am I allowed to, like I said, use a filter, manipulate it, make a derivative of it? Is that allowed? And then in what formats I can put on my website? Can I also put it on my social media? Can I also put it on a flyer or in a brochure? So what formats am I allowed to use it in, and in what territories? Just in the US, worldwide, US and Canada? On the internet, that can be kind of tricky because we think, well, a website can be accessed from anywhere. Everything I'm talking about, I'm couching it in this can I post this conversation, but this applies to all sorts of things, physical certainly. So if we wanted to use a photograph in a book, can I publish that book in every country or only in certain countries? How many copies of that book can I make? Can I use the photograph in the second and third editions of the book? If the book is going to be excerpted in a magazine for a review, can I use it for that? So these are all those sorts of questions we want to make sure to answer. And very important term for a license is how long does that last? Certainly, there are certain things we feel like, well, once it's on the internet, it's there forever. There's kind of some truth to that. So perpetual licenses are better for a licensee, someone grabbing the license, but maybe it's just for an advertising campaign. You only need it for 6 or 12 months. And maybe, the license may cost more the longer that this lasts. So we may limit the term. But it is true, certainly for example, when we're licensing things in for video, for a movie or a television show, even a commercial, we're often getting a perpetual license because once that movie is out there, it's out there for good. You can't get it back, right? There's going to be copies that you've sold. It may be who knows where. And so the length of that license is important. And can't forget payment. This is one of the things, unfortunately, that I hear the most about is I didn't get paid. And so we want to be very clear on how much it was going to be paid, when it's going to be paid, and what the payment is for. Again, all these details that a lot of times we just kind of assume, oh yeah, we get it, we understand. We have this email exchange back and forth or something like that. And hopefully that's good enough, and hopefully there's never any issues around this. Hopefully we never have an argument about it. In my world, I see when there are issues. No one has ever called me and said, hey, nothing went wrong today. No client calls their lawyer to just say hello. Lawyers get phone calls when things go wrong. It's the nature of the work. So you'll forgive my somewhat pessimistic view of these. Well, this could go wrong and that could go wrong. It's just the lens that I have. But it hopefully can be instructive in avoiding those situations. So making sure we are clear on when payment is going to come through or when it is due so that we don't have an argument about it down the road. So those are all really important things to think about when we're using someone else's work. We want to have all those details before we go post someone's information, someone's copyright online on our website, whatever we're using it for. Let's get a license. These blanket licenses I talked about briefly before, and I think the main thing about these blanket licenses is to make sure that the use that you need is provided by the licensor, by the company granting the license. So a very common term for these blanket licenses, a lot of times it'll say non-commercial use only. Most of what we're doing, I would guess, is going to be commercial. I mean, certainly if you're you're creating a little slideshow for your family, not a commercial use. But I would imagine a lot of us here are thinking more on the commercial end of things. These license terms are usually in what we call the terms of use on the website. Sometimes they're called the legal terms. Sometimes they're called the end user licensing agreement. It's usually a little link at the bottom. And just about every website, by the way, should have these terms of use. You'll find it if you start looking, and I'm sure you have better things to do, but you'll find that most commercial websites have terms of use at the bottom that say what you can and can't do on the website. And the terms for these blanket licenses from these, for example, stock websites are really important to review. It may limit the number of copies you can make. It may limit whether you can charge for the use of the copyright or your use of the copyright. So we want to ensure that your planned use fits into those terms being offered. And again, that's something we're commonly doing for our clients is they say, hey, we want to use this video from this website. Can you read these terms and make sense out of them? The terms are sometimes written in legalese, right? In the legal mumbo jumbo we see in contracts. Sometimes they're written in more plain English, and those are fine too. But if they are in legalese, it can be a little tricky. I should also mention, while speaking of legalese, that legalese isn't required to have a license or to have any sort of legal agreement, any sort of contract. A contract requires certain things, certainly, but using the kind of stuffy language, I would say fancy language, but stuffy language that lawyers use with the herefores and therefores and wherebys, is something we learn in law school and has a purpose. But if you're not a lawyer and you need to have a license, you can still have a legally enforceable license without any herefores and wherebys. So it doesn't, while certainly hiring a lawyer is an important thing to do for certain things, I always want to tell people that better to have something in writing, even if it's not written by a lawyer, than nothing at all, as long as it is specific, explicit, and detailed, like I said. So just something to think about. It doesn't mean you have to run to a lawyer every time you need a license. A common question I get is, does posting grant a license? So if I post something to Instagram or Facebook, any social media, does that grant a license? And the answer is, it depends. It certainly grants a license to the website that you are posting to. So when I post something on Facebook, I am granting Facebook a license to use my photograph because Facebook is going to have to reproduce it so that my Facebook friends can see it, right? So Facebook is reproducing. I'm granting them a limited license and talking about it'll probably be perpetual. As far as the length, it'll be perpetual. There's no fee. They don't have to pay me for it. So their license terms are on their website. They have their terms of use, just like I was talking about. But people have often said to me, well, once I put it on Facebook, it's out in the world and anyone can use it. And that is not the case. Now, the terms vary for each website. And I hate to give you homework, but reading those terms, if you want to know what you can and can't do with something that you find on social media, if you want to know what the social media company can and can't do when you post something, you can read those terms. It does not give up ownership. You still own a copyright. If you post something, you still own the copyright. And similarly, if someone else posts something that you see online, they still own the copyright. Generally, for most social media, it does not allow anyone else to use the work that has been posted. So if you see someone's photograph on Instagram, you can't right click save as and go use it as your own. There's a license to Instagram. There's not a license to everybody else on Instagram. And that is an important thing because we do see a lot of that where people find something online and say, well, I'm just going to go use it for my own purposes. And we don't want to allow that. That's not a good idea. But reposting generally is allowed. And that's, people say, well, wait, why can't, but I see everybody else reposting it. So why can't I? You can repost, again, in the terms of use for that social media site. They're going to want you to repost. That's good for them. So they're going to allow you to share that post within the social media. So you can like you can share someone else's post. You just can't take that image or take that video and use it as your own. So these are another question, or rather, I should step back and say, we've now talked about what a copyright is, who owns it, what their exclusive rights are, and how we license and get those rights from someone else. So I've kind of explained what the answer to, can I post this? So far, the answer has been, can I post this? Yes, if you get permission. You can post this if you have permission from the copyright owner. Now, some of you are going to say, well, that sounds like a lot of work. Yes, it may be. And we set it up that way for a reason. But there's also some people who say to me, well, what about fair use? I have to therefore talk about fair use, although it is not a clear-cut way to use anything you want. Fair use it's basically a legal test that allows what is otherwise unlicensed use of a copyright in certain circumstances. So unlicensed means someone else owns a copyright, you are going to use it, but that use is not infringement, it is a fair use. It's not infringing use, it's a fair use. Fair use is created for specific purposes like criticism, comment, news reporting. So certainly, if I am going to write a review of something, I can quote the thing I'm reviewing, or if I'm commenting, if I'm criticizing someone's work, I can, for that purpose, would be a fair use. There's an educational exception for fair use. So we do have these carve outs basically to that exclusive set of rights in copyright, and that's where fair use comes from. It is a lot more detailed than that, so I will talk a little bit about fair use, or I will talk a little bit the details of fair use, and with caution that it is not a free pass. Fair use is just, oh, I'm just claiming it as fair use and therefore I can use it. So there's a lot of specifics about fair use, but it's a complex analysis. The way that fair use works is fair use is a defense to infringement. So you're not asserting fair use and saying, I'm going to go use this, it's fair use. The legal framework for fair use is you're accused of infringement and your defense is, no, Your Honor, it was fair use. Hopefully none of you are ever accused of infringement. Hopefully none of you are ever going to court over this stuff. But that's really, that's where fair use comes from. That's the legal application of fair use. So just to put it in perspective, the reason I mentioned, and it is a defense that requires a case-by-case analysis. So it's not a black and white test. It's not really easy to say, yes, this is fair use. No, this is not. It's a multi-factor test. Multi-factor test basically says when someone is accused of fair use, their defense is judged by a number of factors. So when we are trying to determine if something would be fair use, we look at those factors. I can't say all this without showing you the factors, so I will do so. But these are general things that a judge would have to interpret. So there are certainly times when someone comes to me and says, hey, I want to use this very small part of this nonfiction work, and it is a very transformative use. I mean, I can look and say there's sometimes that things are definitely fair use. But for the most part, a lot of times it's in the gray, a lot of times in between. So what I'll briefly go through these 4 factors just to provide an understanding of the analysis we go through when we're trying to determine it's a fair use, so that if you're in a situation, you're saying, can I post this? And you're saying, I think it's a fair use, you'll have an idea of how to get to, I think it's a fair use, or it is definitely not a fair use. The first factor is the purpose and character of the use. And that is the main question there is our use transformative? Are we transforming the original work into something else for a different purpose? And so if we're changing the type of media that we're using it in, that would weigh in the favor of fair use. But if it's the exact same thing, we're making an exact copy, that would weigh against fair use. The nature of the copyrighted work, what that means is that in general, nonfiction works, fact-based works get less protection than more creative works. And so a painting gets more protection than a phone book, right? Or even research, factual, scientific research gets less protection than a novel. So something that gets less protection is more likely to be a fair use. The amount and substantiality of the portion taken is a factor. So that means I'm using one paragraph out of an entire book versus I'm using one paragraph out of a 3-stanza poem. The amount and substantiality of what you take, if it's a small portion, and also if it's an insubstantial portion, it's not the heart of the work, it's more likely to be found a fair use. And the final factor is the effect of the potential use on the market. So by using someone's copyright, are you damaging their market? Are you taking sales away from them? Are you hurting their likelihood of making money off of their copyrighted work? So one of the things about this is, by the way, you notice it's 4 factors. So 2 could weigh in favor of fair use and 2 could weigh against fair use. And then what do we do? It's really tricky. So this is why we don't regularly rely on fair use, but it is something to consider, or rather, when the question is, can I post this? One of the things we're looking at um, is whether it's a fair use. So it is something wanted to make sure to raise, since I know it comes up. The other thing I wanted to raise, because it comes up so regularly, is about music. It is very common with online use that we want to have music, even if it's just for a slideshow, we want to have music in the background. And the notion that someone creates a song, creates a piece of music, and then owns that music, I've covered all that, right? Music is creative, it's protected by copyright, the owner owns it. What is specifically more complicated in copyright is that in music, is that there's two copyrights in every piece of music. There's a copyright in the composition. So we kind of say what's written down, the word, the music and lyrics. And then there is a completely separate copyright in the sound recording. When we fix that composition in a recording, we often call it the master. And there is a completely separate copyright in the master. So if I write a song, I'm going to own the copyright in the composition. If then Meredith goes and takes my sheet music and records that song, she's going to own the copyright in the master. I don't own that. So it's important to understand this when we're looking at using musical works. The question is, can I post this musical work? Can I use this music in my posting? Because you're going to need rights from both the composition owner and the sound recording owner, because inherently a sound recording, the copyright sound recording includes that copyright in the composition. Any sort of musical work in connection with a moving image requires what's called a synchronization license. We call it a sync license, because you're synchronizing the music with a moving image. When I say moving image, video, television, movies, advertisements, video games, even a slideshow that is going through images every second or every 3 seconds, that is a moving image. So you'll sometimes see, if you ever listen to music on YouTube, you'll sometimes see a video that has music, but it's a still image, right? That there's music playing in the background of this video, but it's just a still image. The reason they do that is because it doesn't require a sync license. But to use music with any sort of moving image, you need to have a synchronization license, and you need to get the synchronization license for both the composition and the master, both the composition and the sound recording, both copyrights. Unfortunately, sync licenses are very expensive. It is the nature of the way the industry is developed. It is a case by case, so you have to ask. It is not a blanket license. It is not a set fee. It is, you go to the owners and say, I need this license, and they will say, how many seconds of the song are you using? Is it in the foreground or the background? Tell me about the video that you're making. What is your budget? They'll ask all these questions, and then they will come back with a quote that may be tens of thousands, hundreds of thousands of dollars. I can tell you that popular music has a very hefty price tag. So when someone says to me, "Oh, I'm creating this little video for that I'm going to use as a Christmas card, and I want to use the Beatles," that's likely going to be out of reach. As I said, there are stock music licensing platforms that will give you a sync license, but it is something to be very careful of, because those infringement penalties that I was explaining before, the $150,000 per infringing act, add up really quickly. I can give you the example. I had a client who they had an intern. This business had an intern, and this is 10 years ago. The intern was like, "Oh, I'm going to make these promotional videos. We're going to start a YouTube channel." And the business was like, "We don't even know what YouTube is. Go ahead, go for it." And this intern created 17 or 18, I can't remember, promotional videos using Stevie Wonder, Michael Jackson, the Beatles, all this great music. And those videos sat on YouTube and no one really watched them for 8 or 9 years until the owners of that music found those videos online. And even though they only had a few hundred views, the owners of the music said, yeah, you should have gotten a license for that. We'll be generous, pay us $300,000 and we won't sue you. Um, Not a situation anyone wants to be in, and cautionary tale on why to get licenses. And by the way, I see Meredith put in the chat. Yes, please ask questions in the chat, not in the Q&A, but in the chat, because I know I'm going through a lot of stuff here, and it may get confusing. And I definitely want to make sure I'm answering questions as well as just talking and talking and talking. Because lawyers love to hear themselves talk, so I'm happy to keep going. So the other thing about music licensing is that when we put music on the internet, when we post music, we are publicly performing the music. A public performance doesn't only mean a live performance on a stage, it also means anyone in the public hearing music over a speaker. So even listening to music on your phone is a public performance. So there's other things to think about when we are using music in a video, and one of them is what we call a public performance license. There are performing rights organizations, we call them PROs, that allow for or that provide blanket licenses for public performance. So, for example, a television channel, a network is going to have a public performance license because there's all the music that's in the background of their shows and their advertisements are public performances of that music. So they're going to pay these PROs for the license to publicly perform that music. Similarly, this can be an issue if you want to, let's say, put a video on your website. Do you have a license to publicly perform that music as users of your website, other people on the internet, are listening to it, it's being performed and therefore requires a license. There's also something called a mechanical license, which is the mechanical reproduction of a composition in a sound recording. So it's getting a little detailed, but it is also it's a number of ways to say we just want to be really careful when we are using music in any sort of video. Let's see. Okay, so we have some questions about photographs. I'll make sure to get to those as I'm kind of getting through a few more slides, and then I will get to all these questions that were specific about the stuff we've been talking about. There are exceptions to these things that I've been talking about. So I want to talk about those exceptions as well. The most common one that I get is, well, everybody does it on YouTube. Yes, we do. See that a lot. YouTube is an exception in a number of ways that generated really from, there was a very long, like 10-year long lawsuit when YouTube first started out quite a few years ago, over a decade ago, that Viacom, which owns a lot of movies, TV shows, sued YouTube and said, YouTube, you have all of our TV shows up on your website, you're blatantly infringing. And YouTube said, hey, we didn't do it. It was our user. Someone else uploaded that Seinfeld episode. So that user infringed. We didn't do it. And this went back and forth, as you might imagine. And what YouTube did is they created something called their Content ID system. And YouTube has basically a database of every television show, every song that's been released, every movie out there. And when any of us upload a video to YouTube, YouTube's Content ID system checks it against everything in their database. Says, is that a Seinfeld episode? Is that a Stevie Wonder song? Is that a movie? And to make sure that there's nothing infringing. And if it gets a hit, it has a relationship with the owner of the Stevie Wonder song. So they'll know, should we take it down? Should we leave it up? Or should we just leave it up and monetize it for you? And that is why you will find so many infringing works on YouTube, because a lot of them are allowed to stay up because they're getting monetized. A lot of them don't get caught by the Content ID system, and the owner doesn't know it's out there. the example is my client who had the 17 or 18 videos up on YouTube for 8 or 9 years. They just didn't get caught. They slipped through the cracks. But that doesn't make it okay because now they're getting sued, or they were going to get sued. So the fact that someone's getting away with it doesn't automatically make it okay. Um, and so I think that is always a good example, maybe from even our kids. When our kids say, well, everybody else is doing it, it doesn't mean it's okay. My mom used to say, if everyone else is going to jump off the Brooklyn Bridge, does that mean you would too? It doesn't make it okay. But there's also something called Creative Commons. So Creative Commons is what we call an alternate licensing scheme. And what that means is owners of copyright works claim their works under Creative Commons, which grants a blanket license to the world. You can look this up on creativecommons.org. It's really interesting. I mean, from a lawyer's perspective anyway, it's really interesting. But Creative Commons is a way that, let's say I'm a photographer, I'm an amateur photographer, and I want the world to be able to use my photographs. And so I post a Creative Commons license on it. And there's, I think, 6 different types of licenses that grant certain rights with certain restrictions. For example, I could say anyone can use this, but you can't use it for a commercial purpose and you have to give me credit. Or anyone can use this and you don't have to give me credit. Or anyone can use this for a commercial purpose. There's all these different types of Creative Commons licenses. And so one thing is to look at the Creative Commons website to understand this. The other thing is, if you were to Google, for example, Creative Commons music or Creative Commons videos, you're going to find sources of copyrighted works that have Creative Commons licenses, which will allow you uses so you can post things that would otherwise be protected by copyright. So Creative Commons is kind of like a blanket licensing scheme. And another way to find stuff that we can post online legally without getting a direct license from the copyright owner. Yes, Meredith is right. Keep posting your questions, please. I will get to all of them. I'm just going to get through a couple more slides and then we'll get to those questions. So please keep posting them. Hopefully I may answer your question in the next couple slides, but otherwise I'll get to them. So the only other exception I want to make sure to mention, because it's come up a lot in the past 6, 9, 8 months that we've been in COVID world, when everyone's been posting things online. The question is about live streaming, specifically live streaming with music. So I was saying earlier that to use music in a video, we need to have a synchronization license. That synchronization license is certainly applies towards the use of someone's recording, and the exception is oftentimes someone performing music live. So if I have my guitar in front of my computer playing a Beatles song, a Rolling Stones song, a Stevie Wonder song, and I am live streaming it, well, the owners of the composition, so the owners of that beat, the words and music, will say, well, it's not being fixed, it's not a permanent use, it's a transient use, and therefore a sync license may not be necessary. So if you're going to record it and then replay it all, you will need a sync license. If you're posting it on YouTube, you need a sync license. If it is just a live stream, a one-time use that is transient and not recorded for later use, a lot of times we can get away from having to use that sync license. So I think that I've talked a lot about the basics of copyright, what we have to do, why we can't do it, but really it comes down to some kind of simple, or not simple, some basic questions to think about copyrights or think about when we're trying to answer the question of, can I post this? And the basic questions are, do you have the rights and can you get the rights? If you're using someone else's copyright work in your post, on your website, in your social media, we just want to make sure we clear those rights. That is what clear, and clearing means getting the permission. And that's what we want to do, just to make sure that we're not infringing someone else's copyright. So kind of a summary, I guess. Can I post this? Yes, if you have the rights. Yes, if you license the rights. Maybe if someone else posted it, because you could repost it. Yes, it's in public domain. Maybe if it's a fair use. So that is a kind of good place, I think, to end with my prepared remarks. And I'll now turn to the questions we have in the chat, and make sure I'm answering those. I know we had a bit of a lengthy question early on from Ron. He says, as a sculptor and author, I have created a series of characters that I'm developing into a series of stories and fables. I'd like to offer a free, limited license to encourage other writers to use my characters and the images of my sculptures in the development of stories that follow a number of themes. I would allow them to develop and publish those works, but not to monetize or profit from those. Please comment. I don't know, you ask a lawyer to comment, we could be here all day without a specific question, but I will offer that. So I think that there's a few ways you could do this. And I think I've gone over some of them. Creative Commons is the most obvious one. You can post a Creative Commons license that allows them to develop and publish without monetizing. So for non-commercial purposes, they give you attribution. You may or may not you choose to allow them to create derivatives to alter the work, but I would definitely check creativecommons.org for one option. Another is you create your own website with your own terms of use. I'd have to advise having a lawyer do the work on those with you to specify what uses can and are not allowed. There's certainly, again, blanket licensing allows for this. It's just a matter of doing it properly to be clear or to be sure that that nothing's going to go awry. Basically, nothing's going to go off the rails. But it absolutely can be provided for. Copyright does allow for this under the right circumstances. And obviously, if you have follow-ups, please post. I'm just going to go through the questions in the chat one by one, and please post follow-ups as I go here. See, Kirsty asked, back in the day, Photolabs used to ask a customer for photographer's approval to print their family portraits. I don't see that often anymore. Additionally, I always send final imagery for clients on Dropbox and let them print or use at their discretion. Do I need a direct license document that I attach in each Dropbox folder? Well, Photolabs is interesting because I haven't been to a photo store in decades. I assume they still exist, but you will find, well, I also, yeah, I used to be, I haven't been to a Kinko's in decades either, but I remember I go to Kinko's and they had a copyright policy. I assume they still do. No one wants to get caught up in an infringement scheme, right? No one wants, Kinko's does not want to get in trouble because you're asking them to make copies of someone else's work. So they definitely, there are a lot of rules around that. I think a lot of that stuff has gone online is one reason through apps. And one of the things to keep in mind is every time you download an app, every time you use a website, you're agreeing to their terms of use. Facebook is an easy example of when you sign up for Facebook, you are agreeing to their terms of use, which is basically a contract that says what use is and is not allowed. So with these print shops or with a Kinko's or anything like that, there may be terms of use that you've agreed to when you click to agree. You may be even checking out and you scan your credit card and you have to like press a box on the little screen. You might be agreeing to terms. So that can really vary. But as far as the Dropbox license, it's a really good question. And Kirsty, I don't know exactly what industry you're in or what type of work that you do. You say you're sending final imagery. Maybe you're a photographer, a graphic designer, but that should be, those terms ideally are in a contract between you and your client. One of the things we regularly do for our clients that are photographers, graphic designers, any sort of service provider, is there's a contract, there's an agreement that says your client is hiring you to photograph this wedding, to create the design for this website, to create this logo. It's a really important tool, that contract, not only for these type of questions, but also to make sure you get paid. Because without that license, without that contract, it can be messy if something ever goes sideways. So the easiest way to make sure to kind of provide for that license, basically, to allow them to print at their discretion, is in a contract, in agreement for your services. Certainly, if whatever kind of work you're in, you don't have a contract with the person using your work, um, granting that license in any other way directly to them is still advisable, I'd say. In that it could even be in an email. Hey, here's the Dropbox link. Please note any images, imagery in this Dropbox can only be used for personal use. You may not make copies. You may post on Facebook. You have to credit me, whatever those terms are. And that's why I encourage you to be in a contract, because you may want them to. I certainly remember when I got married and I hired our wedding photographer, we had a contract that said, yes, you can post, the photographer is going to own the photographs. We can post them on social media. We can make copies, but we can't make multiple copies, that sort of thing. And so I can preface every question I answer today by saying I'm not providing legal advice because I'm not your attorney today, but I can speak in generalities about good practices, and that's one of them, is just to make sure we have stuff in writing. And that applies across so many different mediums and for so many different practitioners. So hopefully that is helpful. Marilyn asked about, as a creative district, we often get requests from organizations or state agencies for event photos to use in PR and marketing. Is credit given in the promotion sufficient? We get requests from organizations to use photos. Okay, so I think if you're using someone's photos in PR and marketing, you need permission from the photographer, or rather, you need permission from the copyright owner of that photograph in order to use the photograph in PR and marketing. So simply giving credit is not a license, right? We talked about if you're posting someone else's, or if you're using someone else's copyrighted work, then you need to have a license to use that copyrighted work. So simply giving credit isn't a license. It is, I'm sure, appreciated. And there are certainly license terms that require credit. So you may get a license from the copyright owner that says, yes, you may use this if you give me credit. But credit alone does not provide for a license, does not equal a license. It's a very common misconception. I get this a lot for folks that are writing books, for example. If I just cite my sources, so to speak. And this is, or rather can be, part of a fair use analysis, like I was talking about earlier, that we may look into those 4 fair use factors. When using in a book is the time we do that. Certainly, I would say that using a copyrighted photo in PR and marketing is very rarely going to be a fair use for a number of reasons, and therefore you're going to need a direct license for the most part, I would expect. So let's see, Harriet has a question. When someone pays a fee to BMI, does that allow blanket use of music in their domain? For example, music as background of theatrical productions? Great question. So BMI is a performing rights organization, a PRO, okay? And I could speak for an hour and a half just about PROs, so I will try to make this brief. But PROs are a source of concern for a lot of folks because, yes, we all play, music is performed regularly, certainly in our pre-COVID world, all the time, because we were going to theaters and bars and restaurants and health clubs, and there's always music in the background, and those are all public performances. Now it's more of an online issue. I certainly, unfortunately, have not been to a theater or health club in a long time, but we will be again. And the stuff we're talking about today will still be true after COVID. So I'm happy to talk about that as well. So performing music at a theatrical production is a great example. Well, actually, It's not a great example because it's an exception. So when you pay a fee to BMI, what you're basically doing is you're getting a license from a performing rights organization to publicly perform the music. So if I own a bar and restaurant and I am playing music in the background, I am performing that music. Whatever music is playing is being performed in my establishment. I therefore must have a performing rights license because whoever wrote that music owns the copyright in that music. And when they own the copyright in that music, they own the exclusive right, as you'll remember from that early slide, the exclusive right to reproduce, display, perform that copyrighted work. So basically, whoever wrote that song that's being played in my restaurant, I'm exploiting their exclusive right. I am performing their copyright, but they're the copyright owner. They're the only ones with the right to license to perform that music. Now, the reason we have PROs is because I am not, as a restaurant owner, going to be able to go get a license from the owner of every song I want to play in the background. And similarly, the songwriter is not going to be able to go and grant a license and collect from every restaurant owner in the country. It's not practical. We have PROs to fix that problem. So the songwriter goes to PRO, the songwriter goes to BMI and says, BMI, please go license this to all those places that want to play my music, collect a license from them, and pay me a portion. And so BMI represents millions of songs, millions of songwriters, and they go grant licenses to every restaurant and theater and health club and bar and all those places. And then I, as a restaurant owner, get a license from BMI. I pay BMI license fee. BMI goes and pays a portion of that fee to the song owner, the songwriter, copyright owner of that song that's being played at a restaurant. So that is the blanket license example. The reason I said that theatrical productions are different, I'm sorry you asked this question, but I have to be honest with you, theater is an exception. The PROs license for non-dramatic performances. A non-dramatic performance is a performance over a loudspeaker. It's also a band on stage. Even a band jumping up and down on stage, that's not a dramatic performance. A dramatic performance is there's a story behind it. A musical is a dramatic performance. So for most theatrical productions, you actually have to get what are called grand rights. And the grand rights are for the dramatic performance of music. So having a BMI license generally does not apply to theatrical performance. There are exceptions, as there always are, and I've dealt with a bunch of those. So what I would say is, Harriet, you're welcome to email me. That's why my information is up here for anybody, by the way. You're welcome to email me after this presentation and ask more specific questions because it gets confusing. This is why I have a job. And to me, it's fascinating and interesting, even if to you, it may be a little frustrating. Let's see, it sounds like I've got a question here. Can you explain the limits of educational copyright exceptions? Great question. The educational exception is basically is a type of fair use, essentially. So the educational exception is a way for educators to use copyrighted works without having to pay for a license. And it is far more limited than a lot of people assume. It does not mean that you can go copy whatever you want and use it wherever you want. I'm not saying you're suggesting that, but I know that a lot of people think that. It's like, oh, well, I'm a teacher, so I can go do anything that doesn't, violate all the copyrights. You would never go and Xerox an entire textbook and hand that out to your students, right? That's just not, that's copyright infringement. But what if you Xerox a page, right? The educational exception is what we call narrowly drawn. One thing is it has to be for a nonprofit public institution. So I work with a number of folks that are in the education realm, but they are not school teachers. And it is really limited to nonprofit educational institutions. one of the tricky, I don't know if I've read it since COVID. And I think, and I could research this pretty easily, and you could, again, email me about it. I don't know that it allows for the transmission of copyrighted works. So if you're teaching remotely, I don't know the educational exception will apply. So I guess what I'm saying is the educational exception exists for teachers and for good reason. It's just that there are guidelines, there are certainly barriers, or it's in a box. There are guidelines to it. So we could talk in more detail about that, and I'm happy to do so, kind of more on a one-on-one. Let's see. Ron said you spoke of live stream being okay. I'm a musician who plays live. My pacing and tonality does not follow the original format. If someone else records my set and posts it, does that relieve me from liability? Ron, you're asking law school questions. Yeah, that's a good one for a law school exam. I like that. When I go back and teach again, I'll use that one. Okay, so your pacing and tonality does not necessarily change the fact that you're using someone else's copyright. So if you are playing your own music, you can grant a license to anyone you want. If you're covering someone else's music, that's where we get into trouble, because you may be using someone else's, or you are using someone else's copyright. And if it is just a live stream, I'm not very concerned about it. If someone else records it and posts it, I mean, the liability does lie with them, but that doesn't absolve you from liability. In other words, how we go after people, who we go after. Unfortunately, or if you're a litigator, fortunately, the way lawsuits work is the person bringing a lawsuit is going to sue everybody they can and see what sticks. So they're going to name you, they're going to name the person who posted it, they're going to name the website they posted it on, go after everybody we can and see who we can get down. So it's just not something that, since it's not permissible, it's not something we want to do. How we control it is more challenging. And certainly, look, if you were to be performing a live stream and completely unbeknownst to you and using a system that does not allow for recording, and unbeknownst to you, someone is using third-party software to capture recording and post it online, I mean, I think that you're certainly not intentionally infringing. I'm not worried for you. I'm not looking, I'm not, it's not keeping me up at night, but it is still not something that we want to happen. So that's that's the way I guess I would answer that. Nicholas has asked, with Creative Commons blanket licenses, if the license type necessitates giving the author credit, how obvious does that credit have to be? Can the credit be inside the code? I don't know the answer to this off the top of my head. It should be on the Creative Commons website. I don't think that just doing in the code is sufficient, because the average user is not going to be aware of that. And I'm all about the letter of the law. I am always reading the letter of the contract. It matters what we have in writing. But in an infringement scenario where we are in court, the intent is also important, right? And the effect is also important. So when when it says you must credit, and you say, well, I gave credit in the HTML code that no one can see, or sorry, the average person is not going to see, because most people are not revealing code when they're looking at something. Was your intent to really give credit, or was your intent to avoid it? And Nicholas, this is not about you. I'm not personally accusing you of anything, but I think that really the intent is so the public is aware that you're using it. So my guess is that the just in the code would not generally be seen as sufficient, but I don't know specifically what is in the verbatim or the exact language of a Creative Commons license. So I'm not certain of that, but that's just my gut on that one. Marie asked, I recently had a live streamed show using music that was owned by a musician who was one of the producers of the show. However, it was blocked on YouTube by the company who published the work. I challenged the copyright claim and waiting to hear back. What documentation do I need from the artist and or publishing company to remove the block? So Marie actually brings up an important piece of copyright law that is relevant to the "can I post this" question, and that is the notice and takedown procedure. So when something is posted to a website, as I said, well, YouTube is the example. YouTube does not want to be liable for what all its billions of users post. So YouTube has what is called a safe harbor. A safe harbor means YouTube will not be accused of infringement as long as it follows a legally prescribed notice and takedown procedure. It is in what's called the Digital Millennium Copyright Act. And what it provides for is when a copyright owner sees an infringement on a website, the copyright owner can send a notice to the website asking the website to take down that infringing work. As long as the website takes down the noticed work, the website is not liable for infringement. It also provides for what's called a counter notice, which is when the copyright owner says, take that down, the user, Marie in this example, can file a counter notice that says, no, I have the rights here, put it back up, YouTube. Now, YouTube is not going to get in the middle of this. They are not the arbiter, and they don't want to be because they don't want to be liable for infringement. So as far as what the law says, there is a notice, there's a takedown notice, and there's a counter notice. And then if it gets put back up, the owner has the option, and they're the only option, to file a lawsuit. So that's the next step. Certain websites, such as YouTube, have created their own systems, like a 3-strike system, to take down the or to limit the account of a user who has multiple strikes against them. So YouTube has created their own way of doing this. But really, that is basically, Marie, what happens here is that you will have. I mean, if you have submitted a counter notice, it is now up to the owner to decide whether to file a lawsuit. Generally, and this is true in most infringement scenarios, and I would say it's true in most disputes, I find the negotiation, direct contact can often solve these problems. Whether, I don't know if you've had any contact with the copyright owner, but that when you're talking about the documentation, you would need a license. That's the documentation you need, a license to use the music that you used. And that documentation, when shown to a copyright owner or a complainant, should be sufficient documentation. It just seems like it's going to be a kind of, it's just going to depend on specifically who these parties are. I know I only have a couple minutes left here. Pilgrim has a question. I've seen images that I created years ago under a contract that assigned specific use rights to an organization. Over the years, I've seen the images being used by other organizations in a variety of ways. Do I retain any rights as the original creator? Create under a contract that assigned specific use rights. So it depends on what is in that contract. Basically, if that contract says, I mean, yeah, it really just depends on the contract. If that contract says, organization number 1, I'm giving you the right to do this, but you can't grant those rights to anybody else. I'm granting you a license, you cannot sub-license, then they would not be able, the other organizations would not have the right to use it. If that document you have with the first organization says you may sub-license or you may assign this license, then they would be able to. Assuming you did not transfer the copyright, assuming you did not give up ownership of the copyright, you do retain rights as the original creator, but because you own the copyright. But you may have licensed some of those rights away. I don't know, it just depends on what's in that document. So that's really the underlying, that's the answer is in that document. And a final question, I think I got a minute left here. Talking with a group of other visual artists the other day who were concerned about people using images they posted on their Facebook sites or Instagram. They were wondering about using watermarks to protect their images. Please comment on the use of watermarks. Well, a watermark, the intent, I mean, the functionality of a watermark is it makes it clear someone's using your work. If I put a watermark on my image and then someone steals my image and posts it on Facebook, it's going to be clear to everybody on Facebook that they're using my image. That doesn't change the parameters of the law that say I own the copyright in my image. No one else can use it without my permission. It's subject to the license with Facebook, and so on. So it really it doesn't change the law, but watermarks are a helpful tool to identify and put the world on notice that you own this copyright and you're using and someone should get the license from you. So I hope that answers that question. I am at time, but I do again encourage anyone on this call or your friends, if you're talking to them later, to please send me an email if you have any questions. Also, as Meredith, I'm sure will explain, I'm very involved in Colorado Attorneys for the Arts, which provides pro bono legal services to in-need artists and arts organizations that qualify for pro bono legal services. Pro bono means free, by the way, which is always a good thing. So you can reach out to me, you can reach out to Colorado Attorneys for the Arts, but I really hope this has been helpful for everyone today. I appreciate you spending your morning with me, and I'm looking forward to our next performance here, and I will hand the baton back to Meredith.
Hi, thank you, Dave. I've had the pleasure of hearing you present many times, and I always learn something new. And I know just based from the great questions we had from folks listening in this morning that I believe they did as well. So thank you so much for your time and great information. And we're gonna end today with some live music because we all need that on our Friday. And again, just a chance to really showcase the wonderful creative talents in Trinidad, Colorado, in the Trinidad Creative District. They have been such a wonderful and generous partner putting today's event together. So I saw him log on. James, are you there?
I am here. Can you hear me?
We can hear you. I can't see you. Can other?
Let me see if there's something I can push on my phone to make that happen. There's a camera icon. Let's see if that does something.
There you are, buddy.
Here I am, leaning into my phone. Such a popular position to be in these days.
Thank you. Well, for those watching live on Zoom, I recommend going into speaker view so James can sort of take center stage, and he's prepared 2 or 3 songs to play for us today as we wrap up this morning. So take it away, buddy.
Okay, well, hello everybody out there. This has been a fascinating presentation and quite pertinent to my life. My name is James Richmond, and I play guitar and mandolin in a few bands around the Trinidad area. And these are some songs of mine. This one I call Franklin Street. I wrote this back in the late 70s, and it goes like this. All right. Well, thank you very much for listening to that. That I called Franklin Street. And as I said, I wrote that back in the 70s. I just moved to Denver and was living all alone in an apartment with nothing but a jazz guitar chord book and nothing much else to do with my time. So that's came out of that. This is something from a little bit later on in my life, though somewhat the same style. And I call this K because I bought an old K archtop guitar, and this is the song that first came to me when I was playing it. All right. Well, I owe that to a late 1950s K guitar that came to me with a few songs in it, which is always a pleasant surprise. And this last one I call Nikayla Cries. I call that Nikayla Cries. I hope you enjoyed it, and I want to thank you all for allowing me to play here today, and thank Main Street Live Theater for allowing me to use their stage and their Wi-Fi. Thank you very much.
Thank you, James. That was so delightful. Thank you to Main Street Live. What a great showcase of the arts and venues and creative folks in Trinidad. So we are just so grateful. This has been such a fun morning. Thank you as well to Amanda Palmer for showcasing her printmaking with us at the beginning, and obviously to Dave Ratner for sharing so much great information. I want to give just really a huge thank you and our gratitude to the Corazon Trinidad Creative District, who have done so much work helping us to coordinate today's event, and to Colorado Creative Industries for helping to sponsor it. We're wrapping up this morning portion. I know some of you registered for a one-on-one 20-minute consultation with one of our attorneys. I know actually a few of those attorneys have been listening in this morning, so thank you for offering your time this afternoon. So if you're one of those folks that signed up, you should have received a message from me with a new Zoom link and some extra details. I believe we actually have one spot left open, so if that's something you would like, please email me. You can respond to the message you got from me earlier, and we'll see if we can squeeze you in. First come, first served. I just wanted to throw that out there because it's an opportunity. Otherwise, keep doing what you're doing. We need our artists and our creatives now more than ever. CBCA is doing a lot of great advocacy work and working with partners all over the state. So if there's something we can do to help you in your work, please don't be shy. Marilyn, anything to add as we're ending? I know to put you on the spot, but anything to add?
No, just a huge thank you to you, Meredith, and all of the time that was put into producing and promoting this event. As you said earlier, we've been at this for some time, and oddly enough, it's during a pandemic that we were able to put it all together. Wonderful. Thank you so much to everyone who was involved, and we look forward to many more events working with CBCA. So thank you so much.
Wonderful. Well, we're right at noon, so have a great rest of your Friday. Bye, everyone.
Thank you.